May I please, Lordship, item 3, Lordship. In this case, Lordship, the youngest counsel, Mr. K.R. Patgiri, out of station, Lordship. Other side concern also, Lordship. Mr. A.R. Ahmed, his concern also, Lordship. Any other day, Lordship.
The 2010 matter, we find it very difficult. Thank you. Coming up after 2019. Consent of the side, the learned counsel for the petitioner praised for appellant praised for adjournment. As this is a 2010 matter, long adjournment is refused. List on 16/6/2026.
Your Lordship, I would like to beg for mention item number 2, where due to some personal difficulty, my senior is also not available. Can you please, Your Lordship, fix it after 2 weeks?
This 2010 matter, we are finding it
Yes,
very
Your
difficult.
Lordship.
Yes, that's why only 2 basic matters are listed.
Yes,
And we are sitting in this Saturday only to dispose of this whole case, a 2010 matter.
Lordship. Only
John. Let we wait till they call the matter.
all right, Your Lordship.
Lordship, I beg to mention matter for urgent listing, Lordship. Today, Lordship, we have already filed the matter and eviction drive is
Not
going
today.
on. Lordship, eviction drive is, I've taken permission on the other side. Eviction drive is going on Biyubadi. They have already demolished half of it. There is a standing order of this honorable court which has been violated, Your Honor, directly violated. Also, no notice has been issued on the petitioner, Lordship. And they have already, on that line, they have already started the demolition without issuing any notice and in violation of the, Lordship, the division bench judgment in Sada Telecom, Lordship. That is also been violated, and there is a order, standing order of this honorable court, wherein directly, clearly it was directed to pass a speaking order. It was directed to the DC to pass a speaking order before taking any action.
You see, in these cases, this is Birubadi area that near that
Lordship,
hospital.
Hospital, Lordship.
Hospital.
Lordship.
There, I have passed orders allowing demolition about 4 years back.
Lordship. So these are
If I may take the indulgence with all respect, Madam. So far as this petitioner is concerned, one petitioner, I have just now taken the instruction from the district commissioner. He says, Madam, that today it is not going to be touched, even this matter can come up on Monday. There is no
If
difficulty.
demolition will look into it.
Absolutely, absolutely. Even I have spoken to him, Madam. If this matter
Take
comes up,
it up.
yes,
You will take it up. But you will have to get it now. The second half will not be available.
no, Madam, he is the petitioner.
I know, this is fair.
Yes, he is the petitioner.
You
So
can
this,
get it.
this matter may come up on Monday, Madam. That is my humble prayer. There is no urgency because I have just now taken the oral instruction.
No, you see, that's difficult. Because then you will have to record your undertaking, not.
Yes, yes,
not look at it.
yes, Lordship, Lordship may record my undertaking, Madam.
No, but even for that, we'll have to have the record
Yes,
to pass an order.
we will try to get it like as soon as possible, Lordship. We are trying our best.
Wait, because second half, there's been a death I have to attend it.
So if I may submit the order, Lordship, the order of this honorable.
Without file, you want to argue.
Lordship, no, only for the listing, Lordship. Only for the listing.
You permitted that.
Lordship. I have lied. Okay.
Yes.
Item 1.
So this is also a very old pending matter, Your Lordship. Just now I have been informed by the relative of the respondent, Your Lordship, that the respondent has passed away. Just now in court, I have been informed by the relative of the respondent.
He is expired.
Death of the respondent, Your Lordship, the sole respondent. Just the relative has informed me in court at this.
You are for the respondent.
Yeah.
I'm the relative of
He is a relative, not the counsel, your lordship. He has just now.
Nasiruddin Ahmed is expired in the year of 2020. So
Mr. B.J. Mukherjee, learned counsel for the appellant is present. Next, Mr.
A. Hussain.
A. Hussain, learned counsel. Has submitted that you are not in the matter.
No.
He submitted that he is not the engaged counsel in the matter. However, the respondent number 1 is related to him and he knows the sole respondent.
This is the principal respondent, there is a performer respondent.
Okay, the respondent 1 has expired.
Expired.
When he has expired?
On 21 of April.
This year?
No, 2020. 2020.
2020?
2020.
He has expired on?
21st April.
21 April 2020. So accordingly, the learned counsel of the informant shall provide his telephone number to the learned counsel for the appellant and provide the names of the legal representatives of the deceased. Next, in the meantime, the learned counsel for the learned counsel for the appellant shall seek instructions and take appropriate steps if respondent number 1 has expired. This being a whole pending matter, just again, due date after 2 weeks.
Not okay.
Item 2.
Your lordship.
Yes.
Your lordship, in this case, we filed an appeal since we are aggrieved by the degree and judgment of the learned civil judge Karimganj in title Appeal 81 of 2006. Since in there the substantial question of law arises because the reason for which we file this appeal, those points were not framed in the issues. Since the issues were mainly about whether the rent was 1,500 or 400. And your lordship, in the written statement by the defendant, also in the trial court, it was not mentioned by the defendant whether the monthly rent was 400 or 1,500. And your lordship, in regarding to PW1, the plaintiff was not.
Just a moment. Is the trial court judgment?
Your lordship, at 32, case number 32.
52.
Yes, sure. Your lordship, on title appeal 81, 2006, it is on page.
No, we are on suit. Judgment is the suit.
So, your lordship, at page 39.
Your this the second appeal has been admitted. The second appeal would not be maintainable under order 40. This is an order passed under order 21 rule 41 rule 25 against an order of demand under order 41 rule 25. No second appeal is permissible. So there is no decree. The technical part is that when otherwise an order of remand is passed under 23, rule 23, then the appellate court does not have session of over the matter. Therefore, under order 41 rule 43 rule 1U, an appeal is permissible. But when it comes to order 41 rule 25, the matter is just sent for a determination and
But your lordship, the issues framed by the trial court is not relevant to the vaccine issue of our case. The main points were not framed in the trial proceeding. Your lordship.
your name?
N. Goswami.
Heard Mr. N. Goswami, learned counsel, appearing on behalf of
M.K. Chodu, senior.
uh, available, appearing on behalf of Mr. M.K. Chaudhary, learned senior counsel for the appellant, non-appear, appears and call for the respondents. Next paragraph. This appeal is directed against the first appellate judgment and decree dated 10/3/2010, passed by the learned civil judge Karimganj in title appeal number 81 of 2006, by which the judgment and decree dated 29/8/2006, passed by the learned civil judge within bracket junior division bracket close number 2, comma, Karimganj in TS number 240 of 2003 was set aside and the suit was remanded back for a fresh disposal with the direction to frame an issue as follows. Just give the quoting. Whether the monthly rent for the suit house is rupees 1,500 slash and dash per month or rupees 400 slash dash per month as averred by the respective parties. Full stop. Next paragraph. It may be stated that by the impugned judgment and decree, impugned judgment and order dated 10/3/2010, comma, the learned First Appellate Court had held that the appeal is allowed on contest, and by invoking Order 41, Rule 25 of the CPC, comma, the proceedings of TS number 240 of 2003 was remanded back to the trial court to decide this suit afresh by directing the plaintiff to appear as witness and prove her case, as well as by framing an issue as already stated herein before. Full stop. Accordingly, comma, the appeal was allowed on contest and the judgment of the trial court was set aside and quashed. Full stop. The records reveal that on dismissal, on allowing the appeal, an appellate decree was drawn up. Next paragraph. It would be relevant to quote herein below the provisions of Order 41, Rule 23, Order 41, Rule 23, capital A, and Order 41, Rule 25 of the CPC. In view of the issue involved. Now, after you'll have to quote these three and then say, from the above quoted provisions of Order 41, Rule 23, Rule 23A and Rule 25, it is apparent that if a matter is remanded in excess of power under Order 41, Rule 25, then the requirement of the said provision is that the trial court is to be directed to take additional evidence required. And accordingly, the learned trial court shall proceed to try such issues and the trial court shall return the evidence to the appellate court along with its findings thereon and the reasons therefore. THEREFOR, therefore. Full stop. Thus, comma, in the considered opinion of the court, insofar as the provision of Order 41, Rule 25 is concerned, CPC is concerned, comma, the appellate court continues to be in session, SEISIN, session of the matter, and it calls upon the trial court to record finding on some issue or issues and send the finding to the appellate court within the time as fixed. Full stop. Therefore, comma, if therefore, comma, in this case, as the learned first appellate court had set aside the judgment and decree passed by the learned trial court and remanded the matter back for a first decision, comma, this would be a case where the remand is actually being made by invoking the provisions of Order 41, Rule 23A. I'm not invoking, the remand is within the meaning of 23A. Full stop. As per the provisions of Order 41, Rule 23A of the CPC, it is provided that the appellate court may remand suit to the trial court, even though such suit has been decided on merit. And it provides that where the trial court has disposed of a suit on merit, otherwise than on a preliminary point, and the decree is reversed in appeal, and if appellate court considers that re-trial is necessary, appellate court has the power to remand the suit to the trial court. In such cases, where the remand is made under Rule 23A of Order 41 of the CPC, comma, an appeal would lie under the provisions of Order 43, Rule 1, within bracket small u of the CPC. Full stop. Next, accordingly, comma, the court is inclined to hold that though the learned first appellate court had referred to the provision of Order 41 Rule 25 for remanding the matter back to the learned trial court. Full stop. However, comma, the contents of the order, contents of the judgment clearly indicates that the judgment of the learned trial court was set aside and the matter was sent back for a fresh trial and public or re-trial. Next, accordingly, comma, this appeal would be maintainable, but not as an appeal under Section 100 of the CPC, but it would be a second appeal against orders under Order 43 Rule 1 U of the CPC. Next paragraph. The learned trial court, while deciding the suit, had referred to the pleadings and evidence. No, before that you say, no, just strike it out. Then you say, this appeal was admitted for hearing by order dated 28/6/2010 on the following substantial question of law. This is the order, order sheet. Next paragraph. In the context of above, substantial question of law is framed by this court, on a perusal of the records, the TCR of the trial court, learned trial court, it is seen that the appellant plaintiff, in the plaint, had pleaded that the monthly rent of the suit house, the suit premises, was rupees 1,500 per month. Full stop. Careful perusal of the written statement, which is in the original of which is in Bengali language, the court has failed to find any pleadings in the written statement by the respondent defendant that the monthly rent of the suit premises is rupees 400 per month. However, the plaintiff had examined Sri Ramakanta Dev, RAMAKEN, next KENTA, next third word Dev, DEV. The husband of the appellant plaintiff as PW1. Stop. In course of his cross-examination, a suggestion was given to PW1 that the rent was rupees 400, which was denied by the PW1 So the plaintiff had also examined the officiating postmaster as PW2 who had deposed regarding the service of notice through registered post with AD, which is not relevant for the purpose of the determination of the issues involved here. Next paragraph. The respondents had examined one Progender, Prajendra Prajendra Malakar, as DW1, who in his evidence on affidavit had stated that the monthly rent of the premises was rupees 400. So, however, the said part of the evidence is not borne by or supported by the pleadings in the written statement. Most of the respondents had also examined one Sunil Namasudra as DW2, and Sri Subon, Subon, Subon Malakar as DW3, that Namasudra, who had also referred to the monthly rent as rupees 400, and Subon Malakar as DW3, who had filed the evidence on affidavit on 7/3/2005, and he had also filed an additional evidence on affidavit on 24/6/2025, no, on 23/6/2025, for which objection of the plaintiff side was, appellant plaintiff side was recorded. defendants had also examined one Ramendu Dev, R-A-M-A-N-D-U. Ramendu Dev as DW3, DW4. The sub-postmaster most of the however, it will not be relevant to deal with the evidence of the said witnesses because in view of the substantial question of law framed, the only issue is whether there are pleadings to show that the defendant had projected had made a statement or not in the written statement that the rent of the suit premises was rupees 400. Next para. As indicated above, on a perusal of the written statement, there is no statement by the respondent defendant that the rent of the suit premises was rupees 400 per month. Next, therefore, come out. The other issues are not required. The other issues of the learned trial court on which the suit was decided is not required to be gone into or examined, as the learned first appellate court did not give a conclusive finding on any of the issues raised. The issues decided by the learned trial courts, even except framing of an additional issue as to whether the monthly rent of the suit house is rupees 1,500 per month or rupees 400 per month as averred by the respective parties. In this regard, there is no averment by the respondent in the written statement that the rent was not rupees 1,500 per month, but was rupees 400 per month. Full stop. Next paragraph. Accordingly, in the absence of any pleading in the written statement regarding the rent to be is 400 per month, the substantial question of law as framed by this court by order dated 28/6/2010 is answered by holding that there is no pleadings in the written statement that the rent of the suit premises was rupees 400 per month. So accordingly, the evidence by the DW1 and DW2 stating the rent to be rupees 400 per month is clearly beyond pleadings, and it is too well settled that no amount of evidence which is beyond pleading can be looked into by the learned trial court. Accordingly, the first appellate court could not have invoked power either under Order 41 Rule 25 CPC or under Order 41 Rule 23A CPC by framing an additional issue as indicated above, and to remand the matter back to the learned trial court for a fresh decision after a retrial. which is actually a retrial of the suit. So the absence of next para, in the absence of any pleadings in the written statement stating the rent to be agreed rent of the suit premises to be rupees 400 per month, comma, as though evidence can be led beyond pleadings, comma, the impugned decision of the learned first appellate court to remand the matter back to the learned trial court for a fresh decision on the additional issue framed is found to be illegal and perverse, being contrary to the pleadings on record. Next para, accordingly, the impugned judgment and consequential decree passed by the first appellate court dated 10/3/2010, passed by the learned civil judge Karimganj. Give the second bracket. Now, civil judge within bracket, senior division bracket close, Sri Bhumi. In TA number 81 of 2006, hereby set aside, and the proceedings of title appeal number 81 of 2006 is restored to file of the said learned court. Next para. The learned civil judge within bracket junior division, bracket was number 1, Sri Bhumi, shall send back the records of TS number 240 of 2023, 2003, back to the Court of Learned Civil Judge within bracket senior division, that was Sri Bhumi. In a period of 3 weeks from the date of receipt of the possession of a certified copy of the order. Next para. The appeal stands allowed to the extent as indicated above. First off, under these circumstances, there shall be no order as to cost. Next para. The appellant plaintiff shall produce a certified copy of the order before the Court of Learned Civil Judge within bracket junior division, that was number 1, Sri Bhumi, in connection with TS number 240 of 2003. First of on receipt of on a production of the certified copy, the said learned court is requested to send the records of TS number 240 of 2003 to the learned civil judge within bracket senior division, that was Sri Bhumi. Next para. On receipt of records, the learned civil judge within bracket senior division, bracket was Sri Bhumi, shall issue notice to the respondent and rehear the appeal on the basis of materials available on record, as there would be no requirement of taking any additional evidence in the absence of, in respect of the rent, as in the absence of any pleadings in the written statement. Next part. So the registry sent back, expeditiously sent back the records, respective records to the learned trial court and the learned first appellate court, along with a copy of the order to be made a part of record by the said learned courts. Next, by the appellant shall appear before the civil judge, General Division number 1, Sri Bhumi, within a outer limit of 3 weeks from the date of the order, and produce a certified copy as in directed above. 3 weeks time you are getting to send the records, to send the certified copy to the court, and the court will remand the matter back.
For action list, item 1 for motion, WPC 2999/26.
Yeah, please, your lordship.
Yes.
This is a petition under Article 226 of the writ of mandamus, your lordship. In this case, the petitioner is a resident of village Ulubari, Birubari, and is residing there since last more than 35 years, on a small government land. And by measuring about
You see,
1
in
meter
this
5 feet.
stretch of land near the TB hospital, the eviction is going on since about 3-4 years back. I had even passed the orders.
Yes, your lordship.
So it is not that you can't say that you are not aware.
No, your lordship, this is the order passed by this honorable court, your lordship. I'm just going to show you kindly pages, your lordship, page 94 and 95. There is a order of this honorable court, your lordship. In 24, and 27/11/24, the order was passed by this honorable court. 7/11/24, and page 94. In this case also, I was the petitioner, your lordship. And page 94.
You are the petitioner. In which matter, which page is your name?
Yes, 77, my lord. Page 77.
74.
Yes, my lord.
Yes, first 77 on the top of the page. Shalendrajit Sharma. And WPC 7389/22.
Yes, page number 76, lordship will find the petition number, my lord. Page number 76, my lord.
In 77, my name is there.
He had earlier preferred, my lord. All these batch of writ petitions were disposed of by common judgment and order, my lord. Page
Let him
76.
complete his part then.
Yes, yes.
Your lordship, kindly page 94 and 95 of my petition. On page 94, paragraph 4, your lordship.
Yes.
Paragraph 4 of the page 94. 50, subparagraph 4. The Deputy Commissioner, Kamrup Metro, is directed to give an opportunity of hearing to the petitioners either personally or through their authorized representative. The Deputy Commissioner shall thereupon pass appropriate speaking orders. The Deputy Commissioner is further directed to allot a particular area in his office where such replies could be submitted. A notice be hanged in the office of the Deputy Commissioner, Kamrup Metro, indicating the area. Further, this court further directs that upon the speaking orders being passed, the Deputy Commissioner shall notify in its notice board
about the fact that the speaking order had been passed for a period of 30 days from such notification, no coercive measures be taken so that if the petitioner are aggrieved, they may avail remedies as permissible under law. And this order was passed based on the division bench of this honorable court in Muhammad Salahuddin. So, but after that, your lordship, representation was also submitted by the petitioner in next page, page 96. We have submitted our representation before the Deputy Commissioner Kamrup Metro. And after that, when hearing was also done, but no order, no any speaking order was passed till date, your lordship. And all of a sudden, they are going to evict my house also, without giving us any opportunity, without giving us any notice or anything, your lordship. Now, I am the occupant of the said land since 1981, your lordship. Earlier also, in another case also, there's some similar petition was passed, similar order judgment was passed by the honorable court, but till that they have not complied with the order.
No eviction unless the order is passed.
Yes. Now, if I may submit, my lord, there, because there were lots of petitioners. Altogether, my lord, there are almost 65 households, my lord, who are in occupation in the part and parcel of land covered under DAG number 97. Admittedly, my lord, DAG number 97 is a part of government land which is reserved for TB hospital. Now the second medical college, that is Pragyatiskur Medical College, has come up. It has been set up, my lord, there. Now, so far, my lord, other occupants are concerned. With respect to them, my lord, speaking orders were passed. A breathing period of, my lord, 30 days were given to them, my lord. Thereafter, they challenged those speaking orders before this honorable court again. This honorable court, my lord, by a common judgment and order, was pleased to dismiss that batch of writ petition. Being aggrieved, they went before the division bench. Division bench also did not interfere. And so far, those persons are concerned, my lord, culminating to more than 30-40 households, my lord, those were evicted. They were evicted, my lord, and the properties has been demolished because that order has attained finality. This honorable court from time and again, my lord, has held that since this is government land and it is required for a greater public interest. Now that, my lord, the Gauhati Medical College, it is being, my lord, demolished in phased manner. So there is a high amount of, my lord, footfall and patient pressure in this, my lord, Pragyatiskur Medical College, that is the TB hospital. Here in this case, my lord, if lordship may be pleased to come to page 109, page 109, my lord. Page 109, they were given a notice, my lord, to participate in that hearing. Now, I have taken the instructions from the district commissioner. Everything is done, only that speaking order is required to be passed. So once the speaking order is passed, my lord, the consequences will follow. So therefore, lordship may be pleased to dispose of this writ petition, my lord, till the speaking order is passed. No coercive action may be taken against
No,
them.
not only that,
My lord.
he has given his mobile number.
Yes.
You'll have to also intimate there that the order has been passed, otherwise people will not know.
No.
The hearing took place in February 25.
Absolutely. Once now, my lord, once the speaking order is passed, it will have to be served to them, my lord.
Yes,
It will have to be served to them. That is the mandate of law, my lord. We cannot escape. In all other earlier matters, my lord, speaking orders were duly served on them. Those were put to challenge in the second round of litigation. So that stage has not yet arrived, my lord. That is my humble submission. So there is no, my lord, apprehension on the part of the petitioner that he will be evicted.
Mr. D.K. Jain, the counsel for the petitioner, also heard Mr. R. Murtaza, the standing counsel for the Revenue and Disaster Management Department, representing respondent numbers
My lord,
One.
respondent number 1.
1 and 3.
Here I can take notice for all the respondents.
Okay, no, because
I'm
Mr. Kalita was there.
He is also there.
For respondent 1 and Mr. N. Kajal and government advocate attending for respondents 2, 3, and 4. Next paragraph. The petitioner projects that he is in occupation of 1 kata 10 lecha of land. 1 kata 10 lecha.
5 lecha. We have claimed for 1 kata 5 lecha.
1 kata 5 lecha.
Yes, sir.
1 kata 5 lecha of land at the outside of the TB hospital at Birubari, Gauhati, and on being threatened with eviction, the petitioner had approached this court earlier by filing WPC 7389 of 2022. And this court, by a common judgment and order dated 7/11/2024, passed in WPC 7389 of 2022 and other linked cases. Had disposed of the said batch of writ petitions with the following orders, with the following operative part of the order. Page 94. Paragraph 50. The operative part of order and paragraph 50 thereof is put in. Next paragraph. It is submitted that pursuant to the said order, the petitioner had submitted a representation before the Deputy Commissioner, Kamrup Metro, within bracket, now District Commissioner, Kamrup Metro, which was received under serial number E-8677070 dated 26/11/2024. So it is submitted that in the said representation, the petitioner has disclosed his mobile number as 977-4430588. 977-4430588. And he had also issued a reminder of reminder on 30 January 2025 that he was not called for hearing. And accordingly, the Co-District Commissioner New Gauhati Co-District by a notice dated 7/2/2025 directed the petitioner to appear for the hearing on 11/2/2025 at 11 a.m. It is submitted that though the matter was heard, but no speaking order was passed. However, a fresh eviction process is being carried out in the locality, and therefore the petitioner appears his eviction without due process of law. Next paragraph. Per contra, the learned standing counsel for the Revenue Department has submitted that he has received telephonic instructions to the effect that the petitioner was heard on his representation on 25/2/2025, and the speaking order has not been passed. So it is submitted that there's every likelihood that in some days that within a reasonable time the representation of the petitioner will be disposed of, and only thereafter the next steps will be taken by the revenue authorities. Next. In this regard, the court is of the considered opinion that in view of the nature of submissions made by the learned standing counsel for the revenue department, it appears that the respondent authorities will not carry out the eviction till the speaking out is passed in terms of directions contained in the judgment and order dated 7/11/2024 passed by this court in WBC 7389 of 2024 in common with other petitions. Next, accordingly, it is provided that without due compliance of the said judgment and order dated 7/11/2024, referred above, petitioners will not be evicted without following due process of law. Next, as the petitioner has disclosed his mobile number, the the district commissioner within bracket Kamrup Metro Gauhati within bracket respondent 2, and the co-district commissioner, New Gauhati co-district within bracket respondent 4, will ensure that orders, if any, passed on the representation of the petitioner will be served on him in such manner as the may be so advised.
You not say 30 days after my notification, speaking order, 30 days may kindly be given.
You're not saying anything. If they don't want to pass for 10 years, you are aggrieved.
No, as per
They will communicate it to you
as per
whether they
direction.
pass.
After the speaking orders, Lordship, 30
Don't
days.
speak when your senior is there on making a statement.
Actually, he has prepared everyone. It's a hurried manner. Sorry, Lordship.
First, my lord, authorities will not evict the petitioner except following due process of law. That is my undertaking before this honorable court.
Accordingly, the matters will be the petitioner stands disposed of at the motion stage
Right.
without issuance of notice on the respondents.
Lordship, a copy of this order may be supplied to us.
The standing counsel for the revenue department and the learned government advocate shall communicate a download order of this court to the
Yes,
respondent.
absolutely, my lord, absolutely. And right now I will communicate.
The petitioner would also serve a certified copy of the order before the respondent number 4 to bring the order to the notice of the said authority.
I'm so deeply obliged.
Right.